What's the target time frame?
It doesn't
Okay.
matter. Can you see us? I've got the camera on, maybe. I don't see it, but good morning. This is Jim Barlow with OakTree Premium Finance. I've done all my webinars, but not today. I have Chris Finley with me today. He's an attorney, does a lot in estate planning, and that's how I use him primarily, but I use him in other areas and technical little areas. We've known each other for 20 years. Seems like a short time, maybe it's a long time, but anyway, we got to know each other doing church work together. And he's the estate planning attorney I use, and boy, it's bad to say, but I don't know that I want to use anybody else. So I'm going to turn off the camera if you can't see it that we're seeing. Maybe you can't see us. Anyway, we're going to get started, and I'll turn over the lectern to him.
All right.
Oh, there's the picture. Maybe it
Oh,
came
there
on
we are.
afterwards. Hello, everybody. All right, now I'll turn it off. Okay. And I think you just, I think you need to just move this down. Or maybe, just go and click on it. Okay, sorry. Getting a few
There we go.
technicalities going.
All
Let me
right.
switch chairs.
All right. Well, this is exciting. I appreciate the chance to do this, and you know, over the years I've done a lot of things with Jim, and I know that he has knowledge, he's smart, and he's experienced, so that means he's wise, and he's kind and honest. And so all those things together, it's kind of rare these days. So it's really neat to come and be able to work with him and talk about estate planning today. So I'm going to see if I can, does this lower a little bit?
Right.
Okay, I'm going to lower a little bit. There we go. That's a little more comfortable. So like Jim mentioned, I'm an attorney. I do mostly estate planning these days, and I work on other areas of law that are related. I do some litigation, and I'll get into that a little bit. But primarily my goal is to make sure that people stay out of court as much as they can. And how that relates to estate planning is that, you know, if we can put together a plan for someone and be proactive with it, then it's going to not only benefit them and give them peace of mind, but also those that they leave behind to make decisions and deal with the aftermath. So let's get into this. So our title here is the 8.5 most common estate planning mistakes. And you have to wait all the way to the end to get to that half. So we'll get to that though. I've listed a few of the top concerns in estate planning and what people think about when they, you know, before they come to see me. First one here is passing someone's estate without involving the courts, and we've kind of talked about that already, but the goal really is to not involve the court as much as you can avoid it, and I'll get into that a little bit more. Number two is avoiding unnecessary taxes. I think that's probably a concern for everyone, and luckily in Utah it's not as much of a concern, but it is still something to think about. Number three is avoiding conflict among children. So obviously, you know, we're hoping that we outlive our children, and when we leave, we hope that our children will get along, and we don't want to cause any problems or leave things open to cause problems between our family, because we want to try to preserve our family relationships even after we're gone. Number 4 is avoiding financial distress due to long-term care expenses. I think this is something that's on a lot of people's minds these days. Trying to make sure that whatever our needs are, if we're not healthy at the end of our life, that isn't too much of a long-term burden on our estate and on our family. Number 5 is preserving estate for a surviving spouse. I think that we all want to take care of our spouse if they outlive us, and we want to make sure that we've done things in a manner that makes things the easiest possible for our surviving spouse. Number 6 is preserving estate after remarriage of surviving spouse. After we just talked about preserving assets for our surviving spouse, I don't know that we always are concerned about what happens to their new interest after we're out of the picture, if that comes up, but we certainly want to make sure that our surviving spouse is still protected. And then number 7 is protecting loved ones, our spouse or children, and our assets or our estate from creditors and predators. So I think there's an element of helping protect them from what they may not think about or see when they maybe get into relationships or business interests that may not be in their best interest. So that's a lot to tackle, but we're going to do it, and we're going to do it hopefully kind of at a quick speed here. So the next slide here says, is knowing enough? Absolutely not, because we can be as educated, we can be as smart as we can read, we can learn, but ultimately we need to take action in order to make that knowledge, put that knowledge to its best use. So a little bit about me. I'm going to talk about how I got here. So I've been practicing law since 2010. I have been a member of the Utah Bar, and I did some work with 2 judges when I was in Michigan. During law school, I was an intern for Judge Aquilina there in the Michigan courts. She oversaw the, as far as familiarity, she oversaw the USA women's gymnastics trial that took place there in Michigan with the coaching staff. I don't know if I want to go into that very much, but she was definitely an important mentor to me. And then also Judge Clark Waddups, who is one of the Utah Federal District Court judges. And so I learned a lot from them, and I learned about, really what I wanted to do in this career and with the law. Have a background in commercial and complex litigation. That was kind of where I started. I learned about bankruptcy first, and then I went into a firm that dealt with a lot of business litigation and also civil RICO and fraud type claims. Got a lot of experience, and probably the most important experience was that I learned that court probably isn't the best place to be working through things. So if there was a way to be proactive with the law, that's the better option. And that's really why I chose estate planning. which I've been doing since about 2012. I do deal with some estate and trust dispute litigation. Really, if there's an estate plan that wasn't well designed, or if there are parties that aren't doing what they're supposed to, generally the trustees or a personal representative that may not be protecting the benefits of or the benefits that the beneficiaries are entitled to, then I can step in and help with that. I don't do that as much. I just do that when I feel like I have the knowledge and the ability to help somebody that is in a bad spot. So officially started Finley Law Firm in August 2017. And this last note here is that I was selected with the Mountain State Super Lawyers so it was each year between 2015 and 2020. And it's a peer appointed designation, which I think, I feel pretty good about, because that means that I worked well within my peer group, and that they feel comfortable with me and my work and my knowledge. So kind of on a more of a personal note, this picture here in the middle is me and my wife when we were first engaged, and she still carries me on her back, just like in the picture. And then we've got these two wonderful kids. On the right is my son Keaton. He's now 10, and that he and I took a trip to Bryce not too long ago, Bryce Canyon. So we took a picture there. And then our most recent addition is Evelyn on the left. She's 4 and 4 going on 25, I think. And she has, such a great personality, and I really enjoy spending time with her. She keeps me young. So enough about me. Let's get down to business here. So, we talk about estate planning and what it is, and like I said, it's proactive planning for your estate. Who do you think hopes that you don't plan your estate? Probate attorneys. Like I said, I want to be proactive, but I have to admit that a big part of my practice is also filing probate matters with the court to settle estates of people that didn't do any estate planning. I don't know how I went backwards on that. The IRS also. So if we don't consider what the tax consequences are of not planning, then obviously the IRS is going to be well satisfied with the taxes that we're paying. In-laws so obviously the spouse of your children, that can always throw a wrench in when they start planning what they're going to do with your estate after you're gone. And then subsequent spouse. I think that we probably don't think about the consequences or potential for fraud or misuse of what we preserve for our surviving spouse, and we want to make sure that it takes care of our surviving spouse and our family. So your estate, let's talk about what that is. It's everything you own when you pass away, and even while you're alive, but it comes more into play once you've passed away. So your house is included, your vehicles, investments, anything that you own, your business interests, life insurance, household items, and all of the things that all of your family members before you have preserved for your benefit. So one of the common questions that I get is, what's the difference between a will and a trust? Or, how is it going to be different for my family if I only do a will or if I do nothing at all? And we're going to talk about that. That's where we get into these mistakes, these 8.5 mistakes. So the very first mistake that we sometimes make is that we fail to name someone to manage affairs if you become incapacitated. So this is something that comes up a lot. When people think of estate planning, they generally think about, what happens after I'm gone, after I'm out of the picture. But there are significant things to consider about what happens if you don't have the ability, you're still alive, but you don't have the ability to manage your own affairs. And that can be either, a mental incapacity or a physical incapacity. And so those are certainly things that need to be considered, especially when it comes to healthcare decisions, financial decisions as well. And I mean, even down to who's going to deal with the utility bills that are in your name. If you become incapacitated, your spouse may not even be able to change the circumstances of your utilities, or shut off the Comcast or whatever it is. So I mean, certainly a consideration that we need to be aware of and plan for. Mistake number 2 is procrastination. And I'm going to put that off talking about that for a minute. No, just kidding. So procrastination, obviously, if you don't plan for your estate, then once you either pass away or become incapacitated, it's too late. We can't really do anything unless we're involving the court. So we don't want to put it off. And I've thought about this a lot. Why do people put estate planning off? I think sometimes it's kind of a taboo thing to think about.
Is it, Chris, a little bit, not to bring life insurance? People don't like to buy life insurance because that means we're talking about their death. Is this, do you think estate planning and life insurance, or we just put them off because we don't want to deal with them?
I think so. I think that's a big part of it, because I don't think anybody likes to think about mortality, because we want to think in terms of what can I do and how am I going to enjoy my life? But we don't think about the fact that it's not infinite, at least in mortality, right? So, we have to think about it. And once we do, and we get the plan made, we don't necessarily have to think about it as much.
I don't know if this totally relates, but investment advisory firms, 92% are never sold. They just fade away.
Really?
Which is outrageous number.
Right.
Because they're receiving a fee income. Oh, I'll think about it next year, 5 years from now. I'll wait till I'm 70. Oh, why do I do it then? So they don't do it.
Right.
92%.
Wow. Well, and the way that I look at it, and I tell clients this a lot, I'm a big believer in Murphy's Law. If you don't do the planning, then you're going to need it. But if you do the planning, you probably won't need it, at least until you pass away. And that's kind of an important time frame. We want we want to make sure that we do the planning to make our family's life easier when we're not there, because they're going to be going, hopefully they're, well, not hopefully, but most likely they're going to be grieving. They're not going to want to deal with the details. And so if we can make it as smooth as possible, it's going to be best.
And a lot of the wealthy of our country, the multi-millionaires, the TV stars, movie stars, they don't have estate plans.
It's true.
And it's a disaster when they pass away.
Right. Yeah, I got to go on the news on Channel 4 a few years back when Tom Petty passed away, because he didn't even have a will and his estate was a mess. So I got to go and speak about that. But it's very common. Either people don't plan, or they on, whether it's on purpose or not on purpose. It's just something that maybe they don't want to think about, like we've talked about, but it really can make a huge difference for your family. All right, so mistake number 3. So we're going to kind of talk about that difference between the will and the trust. But sometimes people only create a will. They don't think about healthcare decisions or decisions for you if you don't have capacity, or they don't set up a trust. So what I like to tell clients is that a will is a wish that you express to the court on how you want things to go after you pass away, who you want to be in charge of decision making, who you want to pay bills, and then who you want to have your assets distributed to. And so, but it does have to go to the court. Whether you have a will or you don't have a will, there will have to be a probate filed on your behalf if you don't have a trust. And the will, I mean, if you can't do anything else, having a will is better than not, because at least you can express your intent on how things should be distributed and who should be in charge. But you do leave those things in the hands of the court. If you don't make any decisions on what happens if you don't have capacity, it's kind of a similar situation where usually a court has to get involved to appoint someone that has authority to act on your behalf. So we do want to include those things in an estate plan so that you can make those decisions now rather than letting the court decide.
When you're 22 years old or 20 and just got married, and you have no estate, maybe more debt than anything, would you say that's you don't need a trust then?
Well, I was recently asked this question in an interview, and my response was, as soon as you turn 18, there are estate planning things that you can do that make sense. Even at a young age, if you have assets, you should consider a trust. But when you're 18, you're not in your parents' house anymore. So there are legal decisions that need to be made. And if you don't have capacity, you need to have somebody named, because your parents can no longer make those decisions. So even starting at that age, you need something in place. But some of the things that you think about that you want to include in a trust would be, if you have real property that you own, if you have assets over $100,000, if you have children that are minors, and certainly if you have any retirement benefits, or especially life insurance, death benefits that you don't necessarily want to go in a lump sum to your children, you can use a trust to collect those assets and control them so that they're not just used to buy, a Ferrari by your child that's 16 years old. So
I guess when I'm remembering when I was young, it seemed like I know a trust costs more than a will. And I remember doing a will for $50. And it seems like the cost stops people from doing a trust when they don't have any money. Is that kind of reality, or?
it is reality, but it may be misinformed reality. And the reason that I say that, we're going to get to that here in just a minute, but the reality is it costs at least as much or more to go through probate than it would just to do a good estate plan.
So if my grandkids are turning, I got a bunch over 18, I should be suggesting minimum have a will.
A will and probably a power of attorney.
Ooh.
And probably
and if,
a healthcare directive.
Oh.
Because, and probably those two documents are maybe even more important than a will. But if we can get at least those three documents, then they have, someone up that they've nominated to be in charge of their stuff if they pass away. They have someone that can make legal decisions for them if they don't have capacity, and they also have someone in place that can make medical decisions for them if they can't. Those are important things that come up for people of any age.
And as soon as
after
they're
18.
willing, do a trust.
Yes.
As soon as you can, but get these things for sure, and don't keep, well, healthcare directive. I think you would suggest that I have a copy at each hospital that I might use.
Right.
See,
Yeah.
even I put things off. Well, I'll get it to them someday.
Right. Well, when you go to the doctor, it's good to have a copy in your hand when you go, especially if it's for an emergency situation.
Oh.
They'll ask you if you're going in for surgery, if you have a healthcare directive, so you want to give that to them at that point. But any doctors that you see on a regular basis, or even your dentist, you should think about giving a copy of that
Really?
healthcare directive too.
Oh, see, I've never thought.
Yeah, because it has the information on it for them to know who to contact to make decisions for you if you don't have capacity.
Because all this stuff happens.
It does. It does, but I like to think that it happens less if we do the work up front.
Murphy's Law.
Back to the Murphy's Law, right? If we plan, then we hopefully won't have to use the plan. But we can also be knowledgeable and prepared to use it if we do need it. So I didn't get too much into trusts, but we'll talk about that a little bit later. So we're going to move on to mistake number 4. And this one is more common than you might think, but people think that because their parents or their grandparents put their children on title or on a deed to real property in the past, that that's a good estate planning strategy. And the truth is that anything that you put another person, you list another person as an owner on, you're opening the door to that person's liabilities potential challenge from an ex-spouse or soon-to-be ex-spouse. And this goes all across the board with all assets. Bank accounts, it's common for some of my clients at the beginning to have their children on their bank accounts as signers, have them on the deed to their home or on a vehicle. And the truth is, if something happens, and it's not always just a creditor, that where people are in trouble with for not paying bills, but it can be, an unexpected auto accident or something that may be their fault. If the insurance didn't cover that and they were still liable and they had a judgment against them, and they were a signer or on your bank account, or they were on title to your house, those assets are exposed to collection on a judgment. So it's really not a good idea. It's not a good estate planning strategy to add your child's name to the title of any of your assets. Mistake number 5. So we have a couple of things here. Down at the bottom, we have failing to disarm the left hand of litigation. And we kind of just talked about that a little bit. Back up to the top, not safeguarding your children's inheritance. So I mean, you work all of those years to preserve something to give to your kids. But if we do estate planning right, we consider our child's creditors, that includes divorce debts. Like I mentioned, the liability that might come with a car accident, possibility of surviving spouse remarrying, inheritance going to new spouse's children. That's another thing that we can address through a revocable trust. Make sure that doesn't happen if we have a surviving spouse that remarries after we're gone. And then finally, forgetting to update beneficiary designations to account for changed circumstances. I want to at least express that, estate planning takes a lot of work initially to get your estate plan set up, but it does take some follow-up. The effort isn't as much, it's not as involved, but you do still have to think about over time, making sure that assets that you acquire are considered in your estate plan. And a lot of times that just means that we're transferring assets into our trust and making sure that our trust is funded. And that's just how we refer to putting assets in the trust and controlling them through the trust.
What is you're probably going to cover this right hand and left hand. I don't.
Well, that kind of comes from a way that a former colleague would explain that, but all of the things that, the potential liabilities that we have against our estate, really we have 5 things that are liabilities as far as litigation goes, and we have 5 things that are tax related that are considerations for us to plan for in our estate plan. So litigation really relates to any action that's taken in court, and so those things are things that we can try to either eliminate or limit through estate planning.
So estate planning is protecting you from litigation and taxes, both, and trying to put the assets where you want it to go.
Right. Exactly. We just want to because we're planning, we want to consider how we can avoid these exposure to litigation and exposure to tax, and really preserve as much as we can for our family. So we've gone from mistake 5 to mistake 6, and now we're going to talk about taxes a little bit. And there are some benefits to tax planning in estate planning, because we don't want to pay more than what we have to pay. We certainly don't want to avoid paying taxes, but we want to only pay what we're required to pay. And there are some ways that we can address that through estate planning. And we'll talk about the different types of tax. For our purposes, we're really thinking about capital gains tax, when we have assets that increase in value. We're thinking about gift tax, which is, there is an amount that you can gift to your family members where there isn't any tax consequence, and that's on an annual basis. And then we're also thinking about estate or an inheritance tax, which is, how much tax needs to be paid when our children or our beneficiaries inherit our assets. And so we're going to talk about that a little bit more, especially the estate tax question. Mistake number 7 is failing to adequately plan for your family business. And this is a big one, because, whatever type of business you might own, there is some element of succession that happens in that business, and that just means, what happens to the business if the owners are out of the picture. If you're a business owner, especially a small business owner, you're thinking about, who's gonna do all this work that I have done my whole life to take care of this business. And a lot of times people don't think about how that's going to happen after they've passed away. And in reality, if you don't plan for that, then that business kind of has to come to a screeching halt until a probate's filed, unless you've considered that and you've planned for that. And you can do that through a trust. Just as an example, if your trust owns your business, or your shares in your business, depending on how the business is structured, the trustee or the person in charge of the trust could step in your shoes and vote either to appoint a new manager or to appoint a new CEO to run the business, where, if you don't plan for that, otherwise, you may be waiting on the court to determine who the best person is to make the decision on who can run the business. And that all stops until we can get in front of the court. Sometimes that takes 6 weeks to get a hearing. So this is certainly something to consider and make sure that we plan for if you are a business owner.
In businesses, there's buy-sell agreements, and insurance gets involved in that oftentimes. But should a business have a buy-sell agreement, even if they're kind of giving the business to the other person?
Or even to a family member or specific beneficiary? The answer is yes to that. And a buy-sell agreement really determines the terms by which that type of a transfer of ownership of a business can happen. The benefit of using life insurance with a buy-sell agreement is that the life insurance can be used, the death benefit can be used to purchase the deceased person's interest, so that capital doesn't have to be taken from the business for a buyout, for a surviving spouse. Is that kind of?
Yeah, I know in my current business where I'm life insurance licensed, the new owner has to be life insurance licensed.
Right.
If I just leave the business to Barbara, well, there's no business because she's not life insurance licensed per
Right.
se. So you need in my case, the buy-sell needs to be with someone who can continue to service the clients.
Right. Yeah, and that is a good point, because any type of business where it does require some type of a professional license, you're right, you need to designate someone that can still run the business that has the appropriate licensure, and those are things that can be addressed through a buy-sell agreement.
In a business, in an investment advisory business, you also have security licenses. And if the broker dealer that you work through doesn't have a copy of a buy-sell agreement that you have, and then you pass away, then they have no choice but to just divvy your clients out to whoever within the broker dealer. But they don't have any instructions
Gotcha.
at all.
And that makes sense. I hadn't really thought about it from that perspective, to really preserve the business in that situation where,
Yeah,
I mean, you've clearly stated who is going to control the business, and that they're going to have that appropriate licensure. Otherwise, the business probably doesn't continue on unless you've done that planning.
And the life insurance company that's paying residuals would quit paying residuals if they don't have a person to pay it to.
Right. It's better to establish that.
So even in I'm not that big of a business, but even in a small business, you should really have that a document in place, a little bit like the trust at 18 years of age.
Right.
Yes, you don't have the assets yet, but get it done anyway.
Right. Because ultimately, if you don't, it will probably be more expensive on the back end if you're not proactive.
Yeah. Okay. Sorry.
So no, that's good. That's good. So I keep pushing the wrong button here. So we'll go back to mistake number 8. So failing to protect your nest egg during your own lifetime. This is an interesting one because you do all the work to earn money over time, invest, make sure that you've created something at least to take care of you during your life, and ultimately pass these assets and this legacy on to your family. In a circumstance where you may need long-term care, or you don't have capacity, you have ongoing health problems, you really can address some of those issues through estate planning. There are different types of tools that you can use. If you know that you're going to have health problems, you can sometimes plan to avoid having to use all of those assets that you've saved for your own care, but you have to do that appropriately through estate planning. I mean, that would be, in the case of being able to have the benefit of Medicaid, or in some circumstances, VA benefits or Social Security benefits. If you do some planning ahead of time, hopefully you can preserve some of those assets so that they don't just get used for your care, but can be preserved and still provide a legacy to your family. All of the things that we've already talked about kind of fall into this category too, where you're thinking about, how you can appropriately plan tax-wise and liability-wise to make sure that you're preserving everything that you can for your use and for your family.
I recently bumped into a lady who wanted some help with retirement planning, but her situation is probably not very helpable. But when in her 30s, her husband got ill. He lost his job. They went on Cobra health insurance, very, very expensive. And even though they still had health insurance, they were having to sell assets to pay the additional money on health insurance, health costs. And therefore, I don't know if they took out bankruptcy, but he also died. But poor planning in a lot of areas can cause big problems.
It's very true. Yeah, you don't really, unless you really don't procrastinate and you take time to actually plan, there are so many things like that where, all it takes is maybe one trip to the emergency room, or, one surgery that was not planned, and pretty soon all of everything that you worked for is gone. Whereas if you would just have done the planning in advance, you could have preserved those assets, even still to take care of yourself. So now we're going to look at our estate planning options. And we're just kind of talking about that. You can end up spending all of your assets, using all of those for your benefit during your lifetime, or even before you pass away, based on what we just talked about, potential medical expenses or liabilities that you might have. You can die intestate. What does that mean? Well, intestate just means that you died without a will. So earlier I said, whether you have a will or you don't have a will, your estate will have to go through probate if you don't have a trust. There is one caveat to that. If you have less than $100,000 in assets when you pass away, your family could, or probably your surviving spouse or your oldest child could create what's called a small estate affidavit, so that they could have authority to take care of whatever expenses are necessary when you pass away, or deal with assets that are under that value. But that doesn't work for real property. So real estate, your home, that wouldn't suffice. So in any other case, you're going to end up in probate court. And if you have a will, then you have at least identified who you would want to be in charge. and where you want things to go. But if you die intestate, it means that we're going to look at the intestacy statute in your state. Obviously, we're in Utah. So we would look to the statute to determine who has priority to be in charge of your estate and who things should be distributed to. So that's what intestate means. Joint tenancy. So this relates to real estate. When you own a piece of property in joint tenancy, it means that whoever survives now has full ownership of that piece of property. So if you pass away, you're a joint tenant with your spouse, and you pass away, then your spouse now owns that property outright. Your estate doesn't have any right to that interest. Ultimately, though, your spouse will pass away, and if you haven't done anything else, then that property, your heirs would have to file a probate in order to appoint someone with authority to transfer that property. So that's not ideal. We'd prefer to be more proactive than that. Beneficiary designation. So with life insurance or bank accounts or investment accounts, in some cases, you can name a beneficiary. Also with tax deferred accounts like a 401k or an IRA, you have the ability to name a beneficiary. That's not always ideal, especially if you're designating, especially a minor child, because a minor child will still just receive a big chunk of money, or their guardian may, whoever their guardian might be. Whereas if you do a little bit more planning, you can control what happens with those assets after you pass away. We've talked about a will as an option. It definitely is a good option to at least have a will. So if you're thinking about good, better, best, and good would be probably power of attorney and healthcare directive. Better would be to add a will, and then best would probably be to consider a trust, which I think is our next option here. So we have a living trust identified there. There are different types of trusts. Important to identify that a living trust is one that you can control during your lifetime. It really is used for the purpose of avoiding probate. So if you have created a living trust and you put your assets in the trust, or you fund the trust, then whatever is in that trust, as far as who you've designated to be in charge, that happens immediately, either upon your incapacity or when you pass away. Your successor trustee. So when that trust is created during your lifetime, you are the trustee. You are in charge of the assets, and you are also the beneficiary of that trust, which means the assets are used for your benefit during your lifetime. Once you pass away, it's an immediate transition to your successor trustee, who has authority to then control the assets that are in that trust. So that is the best option. And we kind of talked about this a little bit. How much does a probate cost? Why does it make sense to think about a trust when you can always fall back on probate? Well, probate costs I have $5,000 in there right now. And that's really just for a simple probate. That means that there isn't any conflict or contest. It means that you have paid the court fee, which is right now $375 just to file that petition. And then you probably have whoever is in charge is entitled to some compensation for the work that it takes to be in charge of your probate estate, which can be pretty involved. I know that Jim has some experience with acting as a trustee, probably not as much acting as an executor or personal representative of a probate estate, but it takes a lot of time. So that's another consideration. I would say that probate costs are probably higher than that now. But I can tell you from the attorney's perspective, it will probably cost, if you have an attorney involved just for a basic estate, for a probate, it's probably gonna be in the $3,000 range just for that part of it. And that's assuming, again, that there's no conflict among the beneficiaries.
You hear about people talking about all the costs of dying, the funeral costs and the burial, and then there's an industry of selling final cost life insurance.
Right.
And you can deal with the mortuary and get plans, but I've never even heard anyone talk about those costs plus these costs.
Right.
They don't talk about them.
They don't. And if you were to compare what has to happen legally for you to like what you're talking about, those prepaid plans, you could almost think of a trust or a trust-based estate plan as kind of a prepaid probate plan, if you think about it, because you're addressing all of those issues. It would almost be a super prepaid plan because you're not involving the courts. I mean, if you went to an attorney and you said, I want to prepay for my probate, because I know that it's going to have to happen because I don't have a trust. If you were to go to them and say that, or to me, I would say, well, why don't you just do it? Get it taken care of now, and then you don't end up in probate. Just establish the trust, set up your own rules on how you want things to go, who you want them to go to and when, and who is going to make those decisions. And then you avoid probate. I mean, it just seems like a simpler option. And in reality, it may even be the cheaper option. Talked about estate exemptions and estate tax. So it's important probably to mention a couple of things. So in Utah, we don't have state estate tax. Estate tax, another name for it would be inheritance tax. So there really isn't any consideration for what the state expects to receive from your probate estate or from your trust. There isn't any consideration that there should be some money changing hands between your estate and the state of Utah. This differs between states, where I think we're pretty lucky that we don't have to think about this. For Utah, in California, it's a percentage of your overall estate. I mean, I guess for taxes it would be anyway, but they're pretty, in California, they're pretty strict on how your assets are transferred and making sure that they get their piece. So we're lucky in Utah to not have to deal with that. Federal estate tax, though, is the same for everybody. And we're also kind of lucky right now that we have these estate exemptions. So during your lifetime, you can transfer either by gift or through inheritance up to $12 million per individual. So you and your spouse can, through your estate, transfer up to $12 million to your beneficiaries without any consideration for taxes that need to be paid to the IRS. Over time, though, you can see here that the exclusion number has increased, and we haven't really talked about what percentage goes to the government. So anything over that 12 million per individual is taxed at a 40% tax rate. So if that's a consideration for you, you have those kind of assets, then we need to do some planning for you so that money, that's not something that's a big chunk that would go to the government, to the IRS. Obviously, that's a big number. And I don't know what Jim's position is, but I know that that's not going to be a worry for me, that at least right now, that my estate would have to be paying taxes.
I do know that my clients who were in that situation, when I tell them this information, most of them thinking I'm lying. They don't believe that the government would do that.
Right.
Because in some certain situations, certainly like in a farm worth 20, 30 million, they've got a big problem.
Right.
How do I pay that whatever million it is?
Right.
When it's all in a farm.
Right. Yeah, that's a good point, because it's not liquid assets, right?
Yeah.
And they've got to come up with a way to pay the taxes. Well, and really the reason that I wanted to bring this up is that, you can see over time that this number changes, and it's not just, it says that it's adjusted for inflation, but this is one of those policies that goes along with whatever the tax policy is currently of the political regime that controls in the United States. So every time that you have a new president, this is something that can be reconsidered during that presidency. And I don't probably have to say that there is some instability in considering what that might look like in the future. So it's something to be aware of. It's something to plan for.
Were you going to mention the current law? The current law expires on December 31st, 2025. Reverts back to something I don't know.
Right. It reverts back. I'm not sure what it reverts back to, but it will revert back if there isn't another policy or if the current policy isn't accepted.
Probably they'll, in 25, they'll do something. We don't know what they're going to do.
We don't know what they're going to do. But this is certainly one of those things that is taken into consideration when we're planning, and we want to make sure that we've covered any risk or liability that's involved with that through the estate planning. So here we go. This is the best way to avoid these mistakes, is to deal with being proactive and start with the revocable living trust based estate plan. That's a lot of hyphens. An estate plan based around a revocable living trust. The best way to avoid probate, to consider the taxes, to consider the liabilities of both you and your children, to be proactive and consider the expenses and the work that it takes to put that in place, almost like your prepaid probate plan. That's pretty good. Quadruple P there. Once you've established your estate plan, you have usually, it's a book of instructions. This is what we'll talk about. So we have in a revocable living trust based estate plan, you have your trust. You want to make sure that it's funded. You have a pour over will, which is still a will that acts as a safety net for your trust, because it says that if you have an asset that didn't get in your trust, you can still file a probate, but you have now made the trust the heir of your will. So anything that's in your estate, your probate estate, would be transferred into your trust and be considered an asset of the trust and be divided the same way that you established in the trust. So we have the pour over will, and that also allows you to designate guardians for minor children if you pass away. You have your financial power of attorney documents and your healthcare, advanced healthcare directive and HIPAA release documents. And then we also have regular updates there at the bottom, because we want to make sure that we do a little bit of work to save a lot of work. We continually, if we have assets that change hands, we acquire new things, we have new people in our lives, or there's a change in the law, we can still make sure that we're covered. Let me just back up one. So we've talked about why estate planning is important, how we can be proactive. Here's our last mistake. It's a half a mistake. And this comes down to what is your source of planning? How are you going to determine the best way to accomplish your goals for your estate? So obviously we can go on the internet, we can read about things, we can grow in our knowledge about estate planning, we can buy computer software, we can buy self-help books, we can go to an attorney that really is only concerned about how many of these estate plans we can crank out, or we can talk to an attorney that's focused on estate planning, that has experience, not only smart, right, having the knowledge associated with estate planning, but also has the experience and is wise in estate planning, like maybe someone that has dealt with some of the issues that come up with trust dispute litigation when things don't go the way that they're supposed to, or when there's a plan that isn't well made. Obviously, I'm going to recommend that people go to an attorney that practices in this area, that's knowledgeable and experienced, and can really help identify what your needs are, what your goals are, and make sure that that is how your estate plan can really operate. Because anything less than that, you don't really know whether it's going to work. And like I said, I make some money dealing with either estate planning that went wrong and didn't accomplish its goals, or situations where there was no estate planning. Proactive estate planning. So here's the old estate planning proverb. What do parachutes, fire extinguishers, and living trusts all have in common? What do you think, Jim?
You gotta have, you gotta have a parachute. Oh, you gotta have a fire extinguisher. If they're no good if you don't have them.
That's
you need
right.
them. Well, so is that it?
Well, you don't know if they work until it's too late to fix them.
Oh,
That's what it really is. And in reality, if you rely on other resources than just going to someone who knows what they're doing, you really don't know whether they're going to work unless you go to somebody that is tried and true and has addressed the issues. So the takeaway really from the whole presentation is you need to do something before it's too late to do something. So that's a lot.
That's a bit, but you've covered the ball game of what's important. I've taken some notes of things I'd like to probably pursue a little bit better on myself. And I hopefully it's been a great introduction to everyone who takes time to watch this webinar whenever they watch it. Thanks, Chris.
Well, thank you, Jim. I appreciate you letting me do this. And as always, it's good to be proactive.
All right. And I'm looking to close it, but I'm not quite there, but we'll get there. All right, maybe. Thanks everyone for attending. Did I end it? Oh, let me get my, no. All right.